baby boomers.
I used to be with it.
Millennials.
Okay, boomer.
Generation X.
What's going now?
And Gen Z. What do they have in common? Not a lot, it turns out. But one thing they can agree on is that this is the political podcast they want to listen to. Welcome to Not My Generation, the political podcast that looks at political events, news, and happenings across the world and at home through a generational lens. Your hosts are Dr. Emily Stacy and Professor James Davenport, two political scientists from Rose State College. But the views expressed on this program are solely the views of the host and their guests and do not reflect the views of Rose State College, its administration, faculty, or students. Coming up on today's program.
This is not boomer-style politics anymore. This is not a boomer-directed campaign, and it's not a boomer-targeted campaign.
If you make specific threats that somebody reasonably fears for their safety because of a specific threat made to them personally, that's where you cross the line.
We make this assumption, oh, these are just unbiased bureaucrats. They're just doing what they think is best, as though they have no interest in asserting their own power or authority in these areas. We know that's not the case either.
When you have a court that professes to just be calling balls and strikes, yet is striking down longstanding precedents, it stands out.
And now, here are James and Emily. Good morning, Dr. Emily Stacy.
Nice. That was nice and well balanced, sir. Very
Thank you.
good. Very
Thank
good.
you. I pulled back just a little bit, but still had some energy, right? Yeah.
I don't know. I'm pretty excited this week. It's been a wonky one.
It's been a first week of the semester and all of the funniness and craziness that goes along with that. You are, if I understand, teaching at a new institution part-time. You're still at Rose. Nobody freak out. Yes. She didn't leave Rose, right? But we're not going to let anybody steal her from us.
They'll have to burn me out of my office. Trust me. I threaten all the time.
So all of that good stuff. Yeah, no, it's been a crazy week. We've had a lot of politics. Democrat National Convention has it. What's your assessment of that? Do you think it went pretty well?
I think that you already know, since we're writing an op-ed on it. I am beside myself. I think that this has been a kind of monumental, game-changing shift in American electoral politics. And I'm not, you know me, I'm not very idealistic about things. And I also don't get my hair on fire, but I preach about, and we preach about on the show quite a bit, generational politics and the ways in which these political parties don't speak to the younger generations. And what I have seen over the last 4 days, particularly the use of popular culture and the infusion of things like Kendrick Lamar songs being played on the convention floor, that tells me that this is not boomer style politics anymore. This is not a boomer, directed campaign, and it's not a boomer targeted campaign.
Right. And I think that was very much what we had with Biden and Trump, right? Two candidates who were boomers, and they were basically talking to boomers for the most part.
There was nothing sexy about it. There was nothing fresh or joyous. The what we have seen over the last few days is a direct and pointed, just a slap in the face of the youth culture, and the youth electorate in this country.
Well,
I think it's interesting.
Harris's campaign has definitely injected an amount of enthusiasm and energy into this that I don't think anybody really expected.
No,
when all of this transpired, I think there were a lot of folks who were like, "Well, I don't know, she didn't have a great 2020," but there's been a lot of energy going on there, and I think, which is interesting, everybody was thinking, the energy was coming from the Trump campaign. That seems to almost have evaporated. Right. I mean, it's like these folks are trying to scramble to figure out, what do we do? What do we say? How do we approach this? Which you would have thought they would have. Come on. The likelihood that Biden was not going to last this campaign had to be.
A contingency plan should have been. Right.
And you would have thought somebody somewhere would have been planning, but they don't. They seem to have been caught flat-footed.
Well, yeah, especially in the last months, especially after the debate, talking about how they were going to push up the margins, right? And turn, traditionally blue states red. I mean, they were on top of it and knew that they were going to blow things out. And this is an about face. So We'll leave you hanging there, so you'll read our op-ed that'll come out probably before this podcast, so you'll know what we're talking about.
But anything else going on? Well, we got a good guest today, a repeat guest, so one of the few
Yay.
that we've invited back.
Surprisingly.
Hey, Dr. Keith Eakins. You want to?
Eakins.
Hey.
Gotcha.
Yeah.
We did this last time.
Yes, we
and
did. Like American Idol Clay Eakins, and I'm sure you just love that parallel in comparison. We love you though. I again have conflict of interest. He was the professor of the only law judiciary class that I ever took. Although
Sheer coincidence, it was the only one you ever took. You never came back.
No, you know me. I'm just a comparative IR Gatch person, right? It's just it's just a thing. But we love to dissect the Supreme Court and all things going on within the application of law on this show as well. And so we're very pleased to have you back. Obviously, you are a professor of political science at UCO in Edmond, which we love. Go Bronchos. Woohoo!
Bronchos.
Exactly. So your research, of course, and teaching focused on the judicial processes, constitutional and administrative law. You are a licensed attorney in Ohio. Do you still have your
I
license?
do, yeah.
Do you?
Yeah.
Keep up with it? Very
Plotting
good.
my CLEs that I'm going to take right now.
Love that. Yeah, we love it. Right, got to keep up with that training. And you and my lovely co-host have recently written an op-ed for the Oklahoma Voice regarding their proposal to reform the judicial selection process here in the state, which we, of course, had our friend from OCPA. And
he came on, Haney, and then we wrote that, and it didn't go anywhere. So look what. You see, we stopped in a track, right?
Love it.
I'm sure that was the thing that
it was all us.
All those legislators were passing that op-ed around saying, well, these what these folks say.
Right? These experts, they know.
I'm sure that's what it was. Yeah. So obviously we don't need to, I don't think we need to do all of the icebreaker questions since we've done them before, right? But yeah.
We made you answer the icebreakers before?
Yeah.
He doesn't know if he's Gen X or boomer, right? I remember that conversation.
Technically a boomer, but, I've the vibes of Gen X, so.
Yeah, very much so. I don't subscribe. Yeah. I don't believe that.
Any research or that you've been reading or writing or anything you want to share?
Actually, I'm really excited. I got a article accepted by the Vermont Law Review, the Vermont Law School, and it's on First Amendment, specifically the fighting words doctrine, and how it applies or doesn't apply to religious speakers, or more specifically the evangelical, the kind of crazy ones that go on campus and preach. Yeah. And basically my argument is that fighting words doctrine does not apply to them. And because there have been situations where these preachers that are kind of over the top get arrested and they're charged with disorderly conduct. And basically the prosecutors would say, well, there's this fighting words doctrine that basically makes this okay to arrest and convict you. So my argument is no, First Amendment protects them. So
very interesting
stuff.
The fighting words doctrine is so interesting to me because, it was it Chaplinsky? Remind me of the case that they kind of laid this down, right? Chaplinsky. And they basically say, obviously fighting words aren't protected by the First Amendment, right? Right. And then my understanding is you had a lot of, some states and some local governments that went around passing laws saying you can't say extra because those are fighting words. Right. These all end up back in court, and the court's like, well, you don't get to predetermine what fighting words are, right? You don't get to say you can't say X because it's the context that matters. Is that right? Yeah,
it's a mess. The jurisprudence is a mess because the Supreme Court basically, while they upheld Chaplinsky on several occasions, at least in theory, what's happening on the ground is they're saying, well, this you can't do this here. But the thing is, the doctrine is alive and well in the lower courts. Mm-hmm. So whereas the Supreme Court has just upheld it in name and basically struck down stuff that's been filtered up to them. The lower courts still abide by it. So it's this weird kind of area where the, kind of what's going on in the lower courts is different than.
So can you give us an example of, a fighting words situation where that speech might not be protected? That the courts would say, okay, yeah, governments can either punish you for doing X or prevent you from doing that.
I think probably just be a real kind of specific threat.
Okay.
So you can be abusive, theoretically. You can be abusive as kind of these evangelical preachers often are, slut shaming, all that stuff. That's okay, but if you make specific threats that somebody reasonably fears for their safety because of a specific threat made to them personally, that's where you cross the line.
Okay. I'm just wondering if there's a certain state school superintendent who's fortunate that the fighting words doctrine is so loosely applied.
Well, he has other things he might have to worry about, like defamation.
Which
is
very good. All right.
Very interesting.
But no, I just find the fighting words thing and the way the court has handled that really interesting.
Yeah, because it's interesting that exists today that we're still talking about, because basically it's what would cause a reasonable person to fight in the street. It's like, would a reasonable person in the 21st century fight in the street? I don't know, but anyway.
All right, so let's get into the meat. I want to dissect this Supreme Court session that has just ended. I think that we have this deeper conversation in political science about the legitimacy of the court. And just overall, I think a lot of us are concerned about the future of the Supreme Court. What do you think, just kind of generally, about the cases that were decided in this session and how consequential they are to our democracy?
Sure. Yeah. First, I'll try not to get too overly professorial, but
please do.
Legitimacy there's kind of two different ways to think about legitimacy, and political science look at specific support and diffuse support for the court. So the theory is, okay, the court has neither the power of the purse nor the power of the sword, right? So as a branch, as the third branch of government, unlike Congress, which has the money, and the president that has the military, the court really doesn't have anything. Their legitimacy doesn't come from this, inherent power of money and force, but rather just their goodwill, their support, their legitimacy. And traditionally, the courts had a lot of this support for themselves as an institution. And over time, it's been fairly sound. The worry now is that with a lot of controversial decisions and the ethics problems, that their well is running low on legitimacy. On the one hand, again, there's diffuse support and specific support. Specific support is basically, well, what do you think about the court based on their recent decision? So that kind of catches like a fleeting opinion about the court that is kind of hinges on how you feel about their recent decisions, like the abortion case, Dobbs, or the Trump case. Diffuse support is a more kind of fundamental support for the court, whereas the way to tap that diffuse support in the public is to ask questions like, well, would you support adding extra justices to the court? Or what would you think if there was a constitutional amendment that took away their ability to hear certain types of cases? And if traditionally the public has been they may not like recent decisions, so their specific support may be low, but their diffuse support of the court as an institution is higher, if that makes sense. So there's kind of different levels of support. There's kind of the fleeting support that comes and goes based on decisions, but then there's also this diffuse support that has been fairly constant. So this is a long-winded way of saying we don't know for sure that the court's diffuse support or the fundamental support for the court is in peril, but there is that danger. Yeah. There's been a lot of high-profile decisions lately where the surveys that ask people questions about, well, how do you feel about the court? They're more tapping into the specific support rather than the diffuse support. So if we ever get a period of normalcy where that's not, where the court's not, raising alarms here and there, we might be able to get a sense of the diffuse support for the court. So again, very long-winded way of saying, I guess it depends. We'll see. But we are concerned that certainly the specific support for the court is at its either lowest or near low in quite a while. So a lot of people are concerned with what the Supreme Court's been doing. There's been a lot of high-profile decisions that haven't been very popular, and it's bad. In a way, it's bad because we depend on we want to have a healthy democracy. We want to have a strong, independent Supreme Court, right? So that's concerning. On the other hand, the good thing is people are talking about the court, right?
Right, sure.
People are talking about the court. They know more about the court. They're starting to talk about, originalism and, is there, was there a sufficient justification for this decision? And what about this precedent that they overturned? So it's kind of good and bad, but we, again, being political scientists, we're concerned about the institution of the court and having each branch having strong powers and independent ways to operate without one branch putting the thumb on the other. Sure. Okay, so that all said, how would I sum up this term? And I thought about this a lot, and I think my buzzword or buzz term or the theme of this term is supreme hubris.
Well done, sir.
This is not based on policy. I mean, full disclosure, I'm politically moderate. I'm not one who's going to hammer the court based on policy decisions that they make. What I'm more concerned about is kind of their lack of judicial humility, their lack of restraint, their kind of lack of concern about the appearance of impropriety with the judicial ethics stuff. And again, the implications that this has for their legitimacy, their long-term legitimacy. In the past, we used to think, well, Roberts, he's an institutionalist. Mm-hmm. He cares about, he's trying to channel Chief Justice Marshall and be concerned about the legitimacy of the court and making sure that it endures over time, that it adapts. But, to be honest, my mom might be listening to this pod, so I'll give you the PG version, but I would say this is, rather than the institutionalist Roberts, this is the no cares given.
Yes, sir. Yeah.
Roberts, he just has no cares to give at this point. It seems like he has he's authored a lot of the opinions that have, struck down longstanding precedent. He refused to meet with Congress when they said, hey, let's talk about these ethical problems. And he basically said, well, no, I don't think that's appropriate. And he says, well, this is just unusual. This is never done. Well, this has been done like 150 times over the past 50 years, something like that. Justices meet with Congress all the time to talk about stuff. This is something that is done, and it's something that is just kind of professional courtesy. This is a problem. This is something that people are talking about. This is something that reporters are reporting about, which they used to not. We need to talk about judicial ethics. So there's that, the ethics thing. There's the overturning of precedent. There's the decision in the Trump case, which again, aside from the policy of it, it's the look of, well, we're creating this whole new concept of executive immunity out of where it didn't exist before, right?
Right. Will you dissect that just a little bit? That case.
Sure. So basically, in Trump versus U.S., that involved, does the question of the court was, does Trump have immunity from prosecution? And the court basically said, yes, he does for official acts. And the court, to kind of boil it down, the court has not only said he has immunity for official acts, but also for unofficial acts, they cannot use, if you try to prosecute a president for unofficial acts, you cannot use evidence of this from official communications and official acts. So, I mean, it's a very far-reaching decision that gives, the long and the short of it, gives President Trump pretty much a get-out-of-jail-free card in this situation. The Supreme Court basically slow-walked the whole thing. Then when they finally decided it, they gave the president sweeping immunity. Again, with no constitutional justification. And it's, and it's pretty much put prosecutors and others in the position where they are really effectively going to be unable to proceed in their cases against President Trump. Certainly not before the presidential election. So that
extends beyond Trump too, though, correct?
Oh yeah, sure.
Right. Okay.
And that was the justification that Roberts gave. He said, this is not just about the current president. This is about future presidents. And fine, I get that. And to be fair, this is something that John Roberts has always been concerned about, is executive power, right? So this is. In his bailiwick, but the extent that he went to, the sweeping powers, again, creating this immunity out of nothing where it didn't exist, which the problem with that is Roberts and some of the others, their mantra has been, well, we say what the law is, right? We are. What did Roberts say in his hearing when he's confirmed? I'm an umpire. I call balls and strikes, and it's not the role of the court to. We're not a legislature. We don't create laws. We take the law as it's presented to us, and we don't make stuff up. There's a great quote from Obergefell that Roberts had this triggered me to look at. And Roberts essentially said, the court is not a legislature. Regardless of what you think about gay marriage, that's not important. Mm-hmm. What's important is what the law is. Mm-hmm. And we are not a legislature. There is nothing here to suggest that there's no constitutional support for this. Therefore, we cannot support this idea of gay marriage. Essentially, that's what he said. That's exactly what he's doing in this case. So that's what's kind of going. It's not the decision, the political valence of the decision. It's that decision that pretty much contradicts everything that you've said that you've stood for in the past, as far as not making up law. So again, it kind of gets to this idea of hubris. It's kind of like we say it, therefore it is the law, even though that law doesn't exist.
Now they didn't go into trying to clarify what they thought were official acts, though, right? So that they kind of left it. We want the lower courts to kind of figure that out. And is that right?
Yeah, and that was another thing that I thought, there's some of these calls that are easy to make. You can make, again, that's kind of throwing it back to the lower courts. Mm-hmm. Again, eating up more time, creating a longer process for this to go on and on. I mean, even John Yoo. I was listening to a podcast that had John Yoo on it a while ago, and even John Yoo, he's the guy that the infamous author of the torture memos during the War on Terror. He basically said, "Yeah, there's a constitutional right to torture, of course." Even John Yoo is like, this decision in Trump versus U.S., like, where's the constitutional justification for that? So if John freaking Yoo is saying
it's problematic.
That, yeah, I mean, this is something that, again, it's the what seems to be somewhat unprincipled, which is kind of galling to people. So yeah, it's this hubris. It's the attack on the administrative state, taking in the admin law cases that basically takes power away from the administrative state, brings it into the court. So I'm specifically here talking about the case of Loper Bright, which overturned the Chevron case. Chevron deference is basically a principle that says if there's ambiguity in the statute, courts defer to what the administrative agencies say. They're the experts on clean water. They're the experts on clean air. They're the experts on, regulating the stock market. If there's a congressional statute, we should defer to what they say. Right. And this is kind of how the modern administrative state has functioned for, over a century. It's you let them decide. And the thing is, Congress passes laws that are general, right? They're broad, they're general. They expect in the modern, in the 21st century and in the 20th century, they expect the agencies will fill in the gaps, make their own interpretations because they're the experts. And what the court literally said was, no, we don't care. You guys aren't experts. We're the experts. We're the experts on interpreting statutes, right? And the counter argument to this is, well, yeah, the courts, they are, they know how to interpret the law. They know how to interpret statutes. Fine. But a lot of this is not, the courts are good at, using Latin and using precedent and stuff like that. The agencies, what they do is apply their expertise. They're the ones that know stuff.
Admin rules process, right?
Yeah, and the thing that's going is the hubris where they say, well, we're the experts, they're not. They make mistakes all the freaking time. The court makes mistakes all the time. There was a case, Ohio versus EPA, where Justice Gorsuch issued this opinion where basically he says he keeps referring to the term nitrous oxide, right? Because it's over the regulation of nitrogen oxide, which involves kind of an esoteric point where nitrogen oxide is going into other states, and how do you regulate this effectively? And Gorsuch issues this decision where he refers to nitrous oxide 5 times. Well, nitrous oxide is like that stuff that people get high off of. It's called hippie crack, right? That's what nitrous oxide is. What the EPA was regulating was nitrogen oxide. It wasn't, this is not a typo. There was literally 5 places in the opinion where this mistake was made. So, the courts are not experts over this really highly technical stuff. And again, what the bottom line is, they've taken power from the administrative state and aggrandized it for themselves. In addition to that case, there's 2 other admin law cases that further serve to give them more power. And just the sum total of it is to give the court more power, taking it from the administrative state. So the big theme of this hubris is, again, no cares given. We're gonna take away your power because we're the experts. Administrative agencies, you don't get to decide, and it's a problem in, again, which leads to the legitimacy question that we talked about earlier.
Yeah.
It has ramifications for that.
Well, I'm going to jump in here for a second because just to push back a little bit, because I have no problem with the court saying maybe we shouldn't just defer to the administrative agency every time there's a dispute coming up. And one of the things that it seems to me is we make this assumption, oh, these are just unbiased bureaucrats. They're just doing what they think is best, as though they have no interest in asserting their own power or authority in these areas or anything like that. And that's not the case. We know that's not the case either. These are people who have their own interests and who have their own aims. And sometimes those can be at conflict with what should be best. And there should be some oversight of that. And so from my perspective, Chevron was decided, in the 80s, I think, if I remember right.
And guess who was a big proponent of it?
Right, it was Reagan, right?
Justice Scalia.
Well, Scalia, yeah, right.
He wrote, so I'm sorry.
Well, they thought that at the time, my understanding, you know more than this, so you can clarify this for me if I get it wrong, but at the time they thought, well, this will give us, the administration, the ability to tone down some of these regulations we don't like without having to deal with the courts. And of course, that's not really what happened. It just gave each administration greater ability to determine, hey, if there's vagueness here, we're going to be the deciders, not anybody else, right? And it's not even the president; it's unelected folks who are genuinely careerist, and yes, they probably are very knowledgeable, but there's a lot going on there besides just trying to find what's the best way to serve the American public. And I think we forget that sometimes and assume that these people are just motivated out of their pure desire to serve the American public, and nothing else factors into their own decision making.
No, I mean, that's a fair point. Although I would say, again, there's always been oversight. So the question is, the question is whether, first of all, is there ambiguity in the statute? Yeah. And secondly, is their interpretation reasonable? Mm-hmm. So again, that's the key term there. If the agency makes a reasonable call on the ambiguity, if they make a reasonable decision, then Chevron suggests that, the court should defer to it. So it's not saying, oh, they're doing this crazy thing or we have to defer to that. It's basically the Chevron deference, which actually has kind of eroded a bit over time anyway. Right. But the idea is that you defer to reasonable interpretation. But that's a fair point.
But I will be honest. I'm not a fan of the administrative state. I understand the need for some level of an administrative state. Don't get me wrong, but
clean air and water, maybe
that's helpful, right? That's
not
a bad
cheating in the stock market where we have all our money invested.
Right.
But just giving it, just saying, yeah, you have a free hand to decide, whatever. Because if the standard is reasonable, and we can interpret reasonable always to be in the interest of the agency, that to me is a problem, right? If I can get to a reasonable decision that is beneficial to the agency, and it's always how this plays out, then I've got a real issue with that.
Yeah, I wouldn't say it's in the interest of the agency, but rather, does it support the mandate that the agency was given? The congressional statute that, the purpose. And
agencies never try to expand their
sure, yeah.
Sure,
they do. Yeah. Sure they do. No.
Anyway, that's enough. I just had to throw my libertarian hackles were getting up, and I had to throw that in there.
I could sense it, James. I was starting to get worried. I was like, oh no, I went too far.
No. Listen, this is why we need these kind of conversations, is because, this produces something that, okay, now we can understand different perspectives, and we can see what is this thing called the administrative state to begin with, and why is it important? I believe it is, right? I just don't want to give it just carte blanche
that's a fair argument
to make decisions.
But again, I'm kind of speaking to the overall theme of this court, and even beyond that, it almost seems like, and I've never been one to accuse the court of this before, because I'm old enough to remember like the Burger Court and Watergate, and not letting President Nixon get away with stuff, and it was really concerned about ethics. But I almost get the sense of this court. It's like they're checking off boxes. Okay, we did affirmative action. We did abortion. We did guns, and now we're doing the and that again, it's not a policy thing. It's the long run health of the institution, and it's a little concerning that the court is too activist. And
yes, thank you.
Remember when we used to talk about judicial activists?
Exactly.
I haven't heard anything.
Thank you.
This is the most activist court. I don't want to get too hyperbolic, but this has been fairly active when you're talking about whether you like Chevron or not. The fact remains is it was precedent for quite a while. And when you have a court that professes to just be calling balls and strikes, yet is striking down longstanding precedents, it stands out.
I know. Look, just stop being tweaked about Chevron.
No.
This is ridiculous.
It's not that, but this is to this larger question of precedent, and it seems like, and I've seen this on the more conservative side. It seems like we only get upset about a precedent being overturned if the precedent is the precedent we don't like, right? And so there seems to be some
definition of judicial activism, right?
Right.
I judge just something I don't like.
Yeah, I don't. Exactly. If it's a precedent that I think is wrong, I don't really have a problem with it being overturned, right? If it's a precedent that I like, then I get all up about precedent, right? And so it seems to me precedent is just, in many ways, a partisan tool that people use to attack the court with. Because if you want to say, precedent is this thing that we should just always honor, well, Brown versus Board of Education kind of overturned precedent, right?
Oh, sure.
So, sure. There are times when we're like, the precedent was bad, and maybe we should do something about that, right? Now, we can have a disagreement over whether or not these precedents were good or bad, but to just say, well, they overturned precedent, so by definition they did something wrong, I think is not a good approach.
No, and I didn't say they're doing anything wrong, but I'm saying that when you're overruling a lot of longstanding precedents, the reality is that raises alarms and hackles, and that.
No, and I get, I get that.
I think a lot of people are concerned, not just me, that endangers the legitimacy of the court because, again, especially when they are proclaiming to call balls and strikes,
right?
When they're creating this new right, because remember that was the big knock against Roe v. Wade, right? Like, well, this was a right that was created. It's not in the Constitution, and when the court struck that down, I'm not saying I was dancing in the streets, but I could intellectually like, okay, yeah, these justices, we knew how they felt about it. Yeah. This is consistent with their ideology. This is consistent with what they profess to do, which is to not be a legislature. But then when they turn around in Trump versus U.S., and this is what that's where it's like, okay, what are you basing this on? Because Roe v. Wade, right? The liberal justice the right to privacy was based on penumbras in the Constitution that said, yeah, the government should leave. There are certain areas where the government should leave us alone, and there's privacy based on, Fourth Amendment and other aspects. There's all kinds of areas where the Constitution gives us some right of privacy. Right. So let's extend those vibes over to, what happens in the bedroom and what happens with how we do our bodies, right? And this is what they're doing. This is vibes. And that's the going thing. I would say that liberal justices, they operate from a standing point of there are principles in the Constitution that in order for the Constitution to survive over time, these principles of due process and the right to and government leaving us alone and what's fair, these have to, and what's cruel and unusual, this has to adapt with the time. So liberal justices kind of cop to that. And Breyer was a good one to kind of explicate this position that the Constitution is living. We don't deviate from these principles. We apply these fundamental principles to what's going on today. Whereas conservatives, they operate from the perspective of, well, no, Scalia famously said the Constitution's dead. It died in 1789 when it was born, and this is how we're supposed to do it. Well, the framers, they had the opportunity to give presidential immunity. Mm-hmm. They chose not to take it. The framers even discussed it, and it went nowhere. The framers gave Congress limited immunity in the speech or debate clause, right? They said you are immune if you're involved in speech. Your activities are immune. They didn't do that for the presidency. Right. That's right. So I'm sorry. I'll get off my.
No. I'm totally in agreement on that because I don't understand how we can going back, the framers specifically, they didn't want a king, right? And this immunity kind of gives you that kind of aura of I can do whatever I want and claim that it's an official act. Right. And it's going to be tied up in the courts for years before that's even determined, much less whether or not I can be prosecuted over it, right? So that ruling seemed very, very anti-conservative to me. I mean, it did not seem like a conservative ruling to me at all.
And again, it's concerning. Again, looking at, I like to think I'm looking at the broader view. It's, again, giving so much power to the executive branch. Again, one of your icebreaker questions was, well, what's the political event that most influenced you? And for me, it was Watergate and the Vietnam War. I mean, and Watergate was just that, look, you can't allow an imperial presidency to metastasize. Right. You need to have a healthy balance of power between the institutions. And again, that's where I get back to the hubris, where I just feel like the court in this term, it's not the policy issues, it's the grabbing of power, it's the giving too much power, in my opinion, to the executive branch, I just have concerns for the long term.
Let me ask you this: is there any legitimacy to the idea that? What the court was trying to do, I'm not saying this is what they did, or the court was trying to prevent a scenario where ex-presidents are just hauled into court forever over whatever policy decision that the next president or some state prosecutor doesn't like, and they tie him up in. Is there any legitimacy to saying, well, that's what the court was trying to do, and maybe they just went further than that? Give me your take on that.
Yeah, I mean, I think that's legitimate, and I again, if the decision was more narrow, Amy Coney Barrett basically supported the decision, but then was like, this thing about not being able to use this as evidence in for unofficial acts, that's going a bit too far. So I would agree with that, and I don't want to go into too much detail here, but I think that the decision is okay. I understand the concern for not going after presidents, and I would support a more limited decision here. But again, it's that this was created out of nothing, and it was a practical decision, but this is not what the conservative justices have proclaimed that what they do. What they do is not supposed to be pragmatic. It's supposed to be based on originalism and textualism. And so again, what you're suggesting is a pragmatic solution, which I agree with.
Right, exactly.
But one that would not go so far.
Well, sometimes the court gets put in that position, right? The Constitution isn't entirely clear. It's somewhat vague, and they have to go to a practical matter, right? That's just the nature of the environment that they're in. But I totally agree with you that this went way beyond kind of what was necessary. If their concern was just, we want to keep presidents from being hauled into court all the time because of whatever.
We love communication that goes both ways, not just you listening to us pontificate. We would love to hear from our audience. If you have comments, suggestions, or would like to contact us about possibly being a guest on the show, please email notmygeneration@raider.rose.edu.
What else? What other cases do we want to jump on? Do we?
Well, maybe that's a good segue for reform.
Yeah, that's where I wanted to go. Good.
Because that was one of the reforms. So President Biden in 2020, through an executive order, created a commission to investigate judicial reforms. It basically impaneled a bunch of experts, a bunch of really smart law professors and judges, and their mandate was not to come up with specific proposals, but rather to just explore different ideas. And that's kind of what they did. It was kind of a brainstorming session. They evaluated ideas, and so they looked at term limits. They looked at jurisdiction stripping, which is, basically the idea of whether or not you can take away certain cases that the court can decide, and ethics and stuff like that. And they just basically discussed these and kind of gave their opinions, but it was all very vague, and it was not, the end game was not to move the ball forward for reform. So this was done in 2020, and then it just kind of sat there. And President Biden, he's an institutionalist, so he's not one to go, he was not spearheading a court packing plan or even an ethics, he was not, and in fact, he got a lot of flack for that, to the point where too much political pressure built up. So he basically came up with, in late July, some proposals for reform. One of those was a constitutional amendment, and the constitutional amendment was in reaction to the Trump v. U.S. case that basically, I think it was called No One is Above the Law Amendment, right? Not a lot of details on any of these reforms, but if, what do I think about it? Takes a lot of political capital to pass a constitutional amendment. You need buy-in from the state level, the federal government level. That ain't happening. I mean, it should be a nonpartisan issue, right? This idea of maintaining institutional balance and making sure that no one is above the law. It should be a nonpartisan thing. And in the abstract, people have been talking about, Republicans and Democrats, liberals and conservatives have been talking about judicial reform and other related reforms for a long time. It's just when we're now in a situation where it's so polarized that we can't, it's hard to extricate this idea, which should be nonpartisan, from the partisan politics of the day. So that's my long-winded professorial way of saying that this ain't going to happen.
Nothing's going to happen soon. For
this constitutional amendment, yeah. The other proposals, let me look at my cheat sheet here. Term limits, 18-year terms. Again, not a lot of specifics in this. Again, this is not something that was brought up just recently because of liberals opposing the court. Certainly, it's getting more. The liberals are more up in arms about it because of the court. But again, this is an idea that's been percolating for a long time. Right. Legal scholars on both sides of the aisles for a long time have been talking about having term limits. And the fact is that the U.S. is kind of an outlier in that area because most countries have term limits for their justices. We do not. We have a constitutional provision that says justices can serve for good behavior, during good behavior. And so how we've interpreted that is a life term. So this is one of the reforms, come up with 18-year terms for the justices. The theory behind it is we kind of this is a good way to keep the justices attuned to modern day society. We don't have an ossified court. We allow judicial selection to kind of be removed from the gamesmanship and chance that exists right now, right? Because you may have a president that has no judicial appointments at all. And then through gamesmanship, another president may have several.
3.
Yeah, so
specifically.
So this is a way to kind of make it more consistent, kind of more take the partisan politics and gamesmanship out of it. Is it constitutional, or would it require a constitutional amendment? The interesting thing is there's divided opinion here. Okay. There's actually a pretty convincing argument that you don't need to pass a constitutional amendment that for having 18-year terms for justices. And the idea here is that the good behavior language doesn't necessarily confer a full-time seat ad infinitum. That what happens in the lower courts, for example, is if a judge wants to retire, they don't have to retire completely. They can go to kind of inactive status, and they can get involved in, maybe if a judge has to recuse themselves. What a concept. And then this judge who is kind of on this semi-retired judge who is on this kind of part-time basis, they can fill in for them. They can have administrative duties. So under one of the, again, not a lot of details, but one of the proposals is 18-year term. You leave the court. You can stay on if you want, but you're just not a full-time jurist. You can, again, be involved in different things with the court and fill in when needed, et cetera. How would this treat the argument would be, well, right now, the justices that are on the court, they were not appointed with this 18-year term limit. So let's say the 18-year term limit was passed by Congress. Well, they could stay on until they decide to retire and then eventually. So you could have theoretically, you could have a 15-justice, court until the current members of the court decide to go off. But again, 18-year terms, the way it would work is like the first and third year of every president, there would be one appointment. So every president gets one appointment or two appointments, the first year, the third year, and it would cycle through that way, and it would take the politics out of it. Yeah. Again, so I think there's a fairly good argument to say that, this for good behavior, it's okay. 18-year term, you can stay on, but you're not a full-time member. Mm-hmm. Others would say, well, no, for good behavior means a life, that means a lifetime appointment, and there's no modifications of that. It's in the eye of the beholder there, but that's
well, if Congress were to pass something like that, right? who's going to be?
I know where you're
who's
going.
going to get to decide?
That's the sticky wicket, as my grandpa
whether or not
would
we
say.
agree that they could do that, they should be able to do this. At the end of the day, those 9 justices sitting there are going to be the ones deciding whether or not you have to have a constitutional amendment, right?
Sure. And on ethics codes, right? Because we know of, which is the next reform I was going to get to, the ethics code. If Congress comes up with that, an enforceable ethics code, somebody will challenge it. And guess who gets to decide? And guess which 2 justices right off the bat are going to oppose that sucker? Well, Alito has said publicly that that's a violation of the separation of powers. Okay. I think that's a weak argument because Congress regulates the court in all kinds of ways.
Right. That's right.
I mean, right now, what's the flap about? Justice Thomas hasn't reported millions of dollars worth of stuff that he's gotten from Harlan Crow over the years. Well, what's the basis of that? Well, he didn't file something. Well, what was that based on? Congressional law that said officials have to, so. I don't buy that argument.
Yeah, agree.
Well, the Constitution basically gives Congress the ability to regulate the jurisdiction of the court, right? And
there's that,
so I mean,
there's all kinds.
So it would seem there are some maneuvers there that if Congress was intent on doing something, that they could make.
Their budget, their salaries. Remember, like during the whole Marbury versus Madison thing, that the Congress actually canceled the court session not once but twice. I mean, it's I'm sorry, I don't buy that separation of powers argument.
No, I agree.
Especially, okay, I know Alito wasn't in on this, but let's talk about the OG power grab here. Marbury versus Madison.
Yes.
Where's that in the Constitution, right?
Yes.
Where is it in the Constitution that says the Supreme Court gets to decide what other branches of government can do legally, whether or not it's constitutional or not? They took that power. So, it's all very fascinating, very interesting. But again, I think that reform is low-hanging fruit. Yeah. I'm really surprised that Roberts doesn't or can't pull something together. I don't know. I think eventually the pressure might be too much because things just keep trickling out. Recently, Kagan, I noticed she said publicly something, and she's really good. She famously doesn't even accept free lox and bagels from from former students or whatever. She's doesn't take anything, But she basically said, "Yeah, I support a ethics code that is enforceable," because that's a problem right now. Yeah. The Supreme Court kind of responded and said, "Okay, well, we'll kind of do this little quarter measure here that's not going to be enforceable, but we'll write down stuff that." That we think, but we're not bound by this. We get to decide, how, when to recuse ourselves. But Kagan, again, is in support of something that is enforceable against the court. And I think that's appropriate. I think that's necessary to maintain the integrity and independence of the court for us to be able to trust it. Again, the legitimacy thing. We want to know that our court is not, in the bag for somebody or going to decide things based on money that they received. I'm kind of thumbing for this picture. I know this is not good podcasting stuff, but there's this picture of Justice Thomas swearing in this Fifth Circuit judge. At Harlan Crow's house. Oh my! This is Harlan Crow's. This is a fireplace in his library.
Walk-in fireplace.
6 freaking people can fit in this thing.
Yeah, it's a child's bedroom.
Yeah, and
my goodness.
This is the guy this is the billionaire that's been giving Clarence Thomas RVs and all this, millions of dollars worth of trips, paying for his mother's house or making payments for his RV. I mean, this is not chicken feed. This is a lot of money. Right. to be somewhat fair to the court for a long time has been kind of operating on the honor system with this stuff, and they've kind of taken stuff, little perks here and there, like Chief Justice Warren, went on, went to Bohemian Grove, that back in the day, 3 days at a cabin in Maine or something like that, right? That was on somebody else's dime, right? So the courts have kind of been taking little perks here and there, and they've kind of been on the honor system, but it's the honor system. It's the whole thing's run amok, really, if you look at the scale of what they're taking now. And the argument, Scalia used to complain about the salaries of the judges because they make under $300,000, and that's not a lot when you're in D.C. and you want to put your kids in fancy private schools and fancy colleges and all that. I get it, but it's public service. You serve on the Supreme Court to be a public servant because you believe in public service, and you don't serve on the court to make connections with rich people. And again, it's just concerning because the appearance of impropriety is so strong.
Are you or your organization looking for unvarnished, unbiased scholarly political analysis for your op-eds, candidates debates, or interviews regarding all things political?
Well, look no further. We are the Democracy Slingers. We're here to host, comment, educate, or just preach the good word of American politics to your school, club, company, or organization. Get in touch with us at democracyslingers@gmail.com. We're running up against time. Do you have, because I've got two things I just want to throw out at him real quickly, right? So expanding the court, what do you think about that?
Dead in the water. I don't like it. It smacks too much of politics. And again, I don't like it.
Okay.
I'll be quick.
We've talked about this before. I would kind of like to see it expanded over a period of time, maybe giving each administration over a 4-year period the ability to add one additional, and then you kind of don't give one president. We're going to add 4 right now, and one president gets to decide who those 4 are. Yeah. So something that's gradual. I just think as diverse as we are as a country, a few more diverse voices on the court would be warranted. But I don't want to give any president the ability to just lop. Here we go. We got 4 more folks that all agree with me, kind of a situation. The other one is, what about adding to the diversity to the court this way, in which we have 13 appellate jurisdictions, right? Appellate, requiring that there has to be a representative from each of those jurisdictions to be on the court, as opposed to just pulling, because most of them are all coming from very similar places, right? I mean, there's not a lot of diversity, either geographically or educationally, on the Supreme Court.
Or just career-wise. They're all, again, the way that the justices are picked now, they're picked based on ideology. After Souter, it was the mantra for conservatives and the Republicans was no more Souter. So there's it's based on Democrats less so. They're more concerned about diversity. I think they're more concerned about that. That kind of trumps ideology. I'm not saying the ideology doesn't come into play at all with Democratic presidents, but I think they're more willing to kind of moderate the political valence of their selections, but they want to have a diverse court that looks like. Yes. Whereas Republicans are more concerned about ideology. And I think that's the problem with the court right now, is that we don't, Justice O'Connor, Republican, but she was she used to serve in the Arizona legislature. Right. She was a politician. She knew how to compromise. Yep. She was often in the median justice that was able to write opinions because she was able to write them narrowly and not in a way that was too big footing on the court, not going too far, not having too much hubris, to get back to my theme. So we don't. Warren, the same thing. Earl Warren was a politician. Warren forced out Abe Fortas, who basically on the court for ethics violations. Right? They were on the same team. They were both liberals, but Warren was concerned about the legitimacy of the court, and he was a pragmatic politician. And also, Nixon was basically telling him, "Look, if you don't do something about Abe Fortas, we're going to sic the attorney general after him and for his ethical violations." So again, the implication that the executive branch can go after, yeah. So my point is basically that with the court the way it is now, with the justices that are picked based on ideology, we don't have the kind of give and take and concern about appearances and the politics and that I think we used to prior to justices being picked for their ideology. So I think that's a problem. So to get back to what you were suggesting, yeah, I think ideology. I think diversity is important. A requirement that they come from each circuit, maybe. But I know in the good old days, which kind of made me think about where I was going with ideology. In the good old days, geography was kind of not necessarily circuit, but geography was an important thing. Like, okay, we need a Southerner on the court. We need somebody. We need to shore up, support from this area of the country. So this has always kind of been a pragmatic. Again, politics was more on the mind, whereas now it's less that. So I would agree with your point in general that I think that less of a focus on ideology, more of a concern about diversity of opinion and geography and just people who are not all ideologues that are circuit court judges. Let's have people that are like Ketanji that have different experiences to bring to bear on the court. Right.
Amen. All right.
Are you good?
I'm good.
This has been great.
Yeah. Thank you so much.
Thank you very much. No, this has been awesome. We're going to have to do this again sometime.
Indeed.
It's always fun. It's always fun.
Well, we thank everyone for listening, and we want to remind you that
democracy is not a spectator sport.
We'll see you next time.
Hey everyone, this is Deborah, the resident Gen Z member of the Not My Generation podcast family. Not My Generation is produced in the Possibilities Inc. studio. This episode was produced by Santiago Ramones. It was edited by Santiago Ramones. We'd love to hear your thoughts on today's episode. Send a voice memo to notmygeneration@raider.rose.edu and you could hear your voice on an upcoming episode. If you liked today's episode, please consider giving us a 5-star rating and sharing the podcast with others. You can check out previous episodes on any podcast app and on our podcast website at notmygeneration.captivate.fm, where we also provide our show notes. And remember, you can follow Not My Generation on X, formerly known as Twitter, at NMG Podcast, and on Facebook at Not My Generation Podcast. We look forward to interacting with you soon.